Hello everyone and thanks for watching Edupedia videos. Today we are going to study the Payment of Bonus Act 1965. Let us see the applicability of the Act. This Act applies to every factory and every other establishment in which 20 or more persons are employed on any day during an accounting year. It includes the establishments like departments, undertakings and branches. Where an establishment consists of different departments or undertakings or has branches, whether situated in the same place or in different places, all such departments or undertakings or branches shall be treated as parts of the same establishment for the purpose of computation of bonus. Provided that where for any accounting year a separate balance sheet and profit and loss account are prepared and maintained in respect of any such department or undertaking or branch, then such department or undertaking or branch shall be treated as a separate establishment for the purpose of computation of bonus for that year. However, the employees of LIC, universities and educational institutions, hospitals, Chamber of Commerce, RBI, IFCI, UTI, social welfare institutions are not entitled to bonus under this Act. The Payment of Bonus Act provides for payment of bonus to persons employed in certain establishments of the basis of profit or on the basis of production or productivity and for matters connected therewith. Let us see the eligibility for getting bonus. Every employee receiving salary or wages up to Rs 10,000 per month and engaged in any kind of work, whether skilled, unskilled, managerial, supervisory, etc., is entitled to bonus for every accounting year if he has worked for at least 30 days in that year. Salary limit or ceiling of bonus. Where the salary or wages of an employee exceeds Rs 10,000 per month, the bonus payable to such employee shall be calculated as if his salary or wages were Rs 10,000 per month. Let us see the definition of salary or wages. Salary or wages means all the remuneration other than remuneration in respect of overtime work which would be payable to an employee in respect of his employment or of work done in such employment and includes dearness allowance, but it does not include any other allowance which the employee is for the time being entitled to. The value of any house accommodation or supply of light, water, medical attendance or any other amenity or of any service or of any concessional supply of food grains or other articles, any travelling concession, any bonus including incentive, production and attendance bonus, any contribution paid or payable by the employer to any pension fund or provident fund or for the benefit of the employee, any retrenchment compensation or any gratuity or other retirement benefit payable to the employee or any ex gratia payment made to him. It also includes any commission payable to the employee. Let us see the computation of number of working days. An employee shall be deemed to have worked in an establishment in any accounting year also on the days on which he had been laid off under an agreement or as permitted by standing orders under the Industrial Employment Standing Orders Act 1946 or under the Industrial Disputes Act 1947 or under any other law applicable to the establishment. Second condition is he has been on leave with salary or wages. Third, he has been absent due to temporary disablement caused by accident arising out of and in the course of his employment. Fourth, the employee has been on maternity leave with salary or wages during the accounting year. Let us see what are the disqualifications for bonus. An employee shall be disqualified from receiving bonus under this Act if he is dismissed from service for number 1. Fraud, 2. Riotous or violent behavior while on the premises of the establishment, 3. Theft, misappropriation or sabotage of any property of the establishment, 4. Deduction of certain amounts from bonus payable under the Act, where in any accounting year an employee is found guilty of misconduct causing financial loss to the employer, then it shall be lawful for the employer to deduct the amount of loss from the amount of bonus payable by him to the employee under this Act in respect of that accounting year only, and the employee shall be entitled to receive the balance, if any. Let us see how much is the minimum and maximum bonus payable. Minimum bonus. The minimum bonus which an employer is required to pay even if he suffers losses during the accounting year or there is no allocable surplus is 8.33% of the salary during the accounting year or ₹100 in case of employees above 15 years and ₹60 in case of employees below 15 years, whichever is higher. Maximum bonus. If in an accounting year the allocable surplus calculated after taking into account the amount set on or the amount set off exceeds the minimum bonus, the employer should pay bonus in proportion to the salary or wages earned by the employee in that accounting year, subject to a maximum of 20% of such salary or wages. So in short, we can say that minimum bonus applicable, minimum bonus payable to the employee by the employer to the employee is 8.33% of the salary during the accounting year, or ₹100 in case of employees who are above 15 years and ₹60 in case of employees below 15 years. The maximum bonus, it should be 20% of such salary or wages. Time limit for payment. The bonus should be paid in cash within 8 months from the closure of the accounting year or within 1 month from the date of enforcement of the award or coming into operation of a settlement following an industrial dispute regarding the payment of bonus. However, if there is sufficient cause, extension may be applied for. The calculation of bonus. The method for calculation of annual bonus is as follows. Number 1. Calculate the available surplus as the available surplus would be equal to gross profit minus depreciation admissible under section 32 of the Income Tax Act or development allowance. Available surplus deductions would be direct taxes payable for the accounting year calculated as per section 7, sum specified in the third schedule. Direct taxes calculated as per section 7 in respect of gross profits for the immediately preceding accounting year. Calculate allocable surplus. allocable surplus is equal to 60% of available surplus, 67 in case of foreign companies. Make adjustment for set on and set off. For calculating the amount of bonus in respect of an accounting year, allocable surplus is computed after considering the amount of set on and set off from the previous years as illustrated in the fourth schedule. Let us see what is set on. Set on, where for any accounting year the allocable surplus exceeds the amount of maximum bonus payable to the employees, then the excess shall subject to a limit of 20% of the total salary or wages of the employees employed in the establishment in that accounting year be carried forward for being set on in the succeeding accounting year, and so on up to and inclusive of the fourth accounting year to be utilized for the purpose of payment of bonus. Set off, where for any accounting year there is no available surplus or the allocable surplus in respect of that year falls short of the amount of minimum bonus payable to the employees, and there is no amount or sufficient amount carried forward and set on which could be utilized for the purpose of payment of the minimum bonus, then such minimum amount or the deficiency, as the case may be, shall be carried forward for being set off in the succeeding accounting year, and so on up to and inclusive of the fourth accounting year. Set on and set off, where in any accounting year any amount that has been carried forward and set on or set off under this section, then in calculating bonus for the succeeding accounting year, the amount of set on or set off carried forward from the earliest accounting year shall be first taken into account. The allocable surplus so computed is distributed in proportion to salary or wages received by them during the relevant. Let us see what are the duties of the employer. Number 1. To calculate and pay the annual bonus as required under the Act. Number 2. To submit an annual return of bonus paid to the employees during the year in Form D to the inspector within 30 days of the expiry of the time limit specified for the payment of bonus. Number 3. To cooperate with the inspector, produce before him the registers, records maintained, and any such other information as may be required by them. What are rights of the employers? Right to forfeit bonus of an employee who has been dismissed from the service for fraud, riotous or violent behavior, theft, misappropriation or sabotage of any property of the establishment. Number 2. Right to make permissible deductions from the bonus payable to an employee, such as festival, interim bonus paid, and financial loss caused by misconduct of the employee. Third, right to refer any disputes relating to application or interpretation of any provision of the Act to the Labour Court or Labour Tribunal. Right to claim bonus payable under the Act and to make an application to the government for the recovery of bonus due and unpaid within 1 year of its becoming due. Right to refer to any dispute to the Labour Court or Tribunal. Employees to whom the Payment of Bonus Act does not apply cannot raise a dispute regarding bonus under the Industrial Disputes Act. Right to seek clarification and obtain information on any item in the accounts of the establishment. Let us see what are the rights of employees. Number 1. Right to claim bonus payable under the Act and to make an application to the government for the recovery of bonus due and unpaid within 1 year of its becoming due. Right to refer any dispute to the labor court or tribunal. Employees to whom the Payment of Bonus Act does not apply cannot raise a dispute regarding bonus under the Industrial Disputes Act. Right to seek clarification and obtain information on any item in the accounts of the establishment. What are offences and penalties under this Act? For contravention of the provisions of the Act or rules, the penalty is imprisonment up to 6 months or fine up to ₹1,000 or both. For failure to comply with the directions or requisitions made, the penalty is imprisonment up to 6 months or fine up to ₹1,000 or both. In case of offences by companies, firms, body corporate or association of individuals, its director, partner or a principal officer responsible for the conduct of its business shall be deemed to be guilty of that offence unless the person concerned proves that the offence was committed without his knowledge or that he exercised all due diligence. There has been recent amendment in the Bonus Act. The government doubles the monthly bonus calculation ceiling to 7,000 as earlier it was 3,500. Thanks for watching Edupedia videos.